fulfilled the best of rarest of rare case, where the alternative action is unquestionably foreclosed. Sir, appointed by late Sri Pranab Mukherjee, was elevated to the Supreme Court of India on 8th March 2013. He began his legal career when he graduated from the Kerala Law Academy in 1978 with a degree in LLB. He actively and formally started his legal practice in year 1979 in the High Court of Kerala. Within 10 years of his practice, Sir was appointed as a government pleader. Soon he was named as the Additional Advocate General in 1994, and then went on to be designated as a Senior Advocate in 1996. Such impressive was his career trajectory that 4 years hence, Sir was elevated as a judge in the High Court of Kerala. From here on, Justice Joseph served as the President of Kerala Judicial Academy from 2006 to 2008, Chairman of Legal Services Authority in Kerala for 2009-10, Lakshadweep for 2008, and the Kerala High Court for years 2006 to 2009. Sir has also served as the Acting Chief Justice of High Court of Kerala twice and was subsequently appointed as the Chief Justice of High Court of Himachal Pradesh from 2010 to 2013. Finally, following his investiture, Justice Kurian Joseph started serving as a justice in the Supreme Court of India. Justice Kurian Joseph has authored a total of 1,110 judgments in his tenure, perhaps the maximum number, and which also includes the famous cases of Manoj Narula versus Union of India, Supreme Court Advocates on Record Association versus Union of India, Sarah Bano versus Union of India, and the famous Triple Talaq matter. Thank you so much, sir, for your lovely and the most kind gesture to join the people who look up to you in admiration and inspiration. Surely this evening will fall short if we keep counting your achievement and glories, sir, and so we will rather have you to take the podium from here on. We hope you enjoyed this interaction at the Jharkhand Bar as much as we relish the awe-striking presence of yours amongst us. Sir, the entire screen and the entire evening is over to you. Sir, your microphone is in the mute mode, sir. Sir, your microphone is in the mute mode. Yes.
Yeah. Thank you so much. Welcome, and all time persuaded me that is the bar of Jharkhand would be very happy to share this platform virtually for a discussion on some topic. For your information, while I was serving as a Chief Justice in Himachal, maybe the senior members of the bar would know, I was appointed as Chief Justice in the Jharkhand High Court. But the Himachal, the Chief Justice, Chief Minister, and the bar, and the Prime Minister of India also opposed by shifting me from Himachal, because I had done quite a lot of things in Himachal after reaching there. So they, on account of their opposition, I could not move out. Otherwise, my destiny would have been different. I would have been there as your Chief Justice 2010 towards the end. Yeah, that's it. It's all, God has destined you to be somewhere sometime, and you will be only in that place. I'm a firm believer in that principle. It's not destiny, but it is God's design. Yeah, very warm good evening to you, my dear young friends and the senior members of the bar. We have a very hot topic for discussion and very current. And all of us are, I'm sure, various media now, platforms, well aware of what is contempt, though we are not committed in contempt, though we have not been part of any contempt, but we know a lot of contempt law. But still, to have a comprehensive idea as to what is this contempt, I will take you to the constitutional perspective first, and then to the Contempt of Courts Act, and then of course in the context to the Supreme Court rules also. I'm sure the Jharkhand High Court also would have some rules in the matter of contempt of court, whether suo motu or otherwise. The freedom of speech and expression flows as a right under Article 19(1)(a). All citizens shall have the right to freedom of speech and expression. That is the source from which we are going to trace what is and what is the limit to our right. In the preamble, the Constitution of India, we have made a constitution and given to ourselves, securing to all citizens what? Securing justice, liberty, equality, fraternity. And what is that liberty? Liberty of thought and expression. Belief is a different context. But in the preamble itself, the Constitution says every citizen of India shall have it is actually secured. That means guaranteed. Secured the liberty of a thought and expression. And if you see, it promotes fraternity, assuring the dignity of the individual. This is something very important in the context I deal with this matter of contempt. I would request you not to share the screen and not to unmute yourself, because it might otherwise affect your thinking, because we are on a very rare platform of visual and video together. So just coming back to, yes, in the preamble itself, we have the Constitution of India. It has secured liberty of thought and expression, and it has assured the dignity of the individual. What is this dignity without his voice, without his space? After all, ours is a democratic country. And what is democracy? Democracy, the popular meaning, would always say of the people, by the people, for the people. Yes, no doubt. But I would like to describe democracy in two simple words, where all citizens have a space and a voice. If this is ensured, we can confidently say, I live in a country where the principles of democracy are treated sacrosanct. Democracy is a living democracy. After all, democracy is a living concept. Not the simple, you can't confine it to a simple definition. But for the purpose of our discussion, I would like to simply define it as where a country or a system of governance where all citizens who are governed have a right to space in the country and right to raise voice in the country. Well, not to make noise. Make noise is different from raising voice. But unless you have a space, secured space, and unless you have an assured right of the raising your voice in a democracy, in a constitutional way, well, then your dignity is not protected. So this right, constitutionally guaranteed, secured, assured right under Article 19 in the preamble and in 21. Preamble 19 and 21, dignity. Right to live with the dignity. Right to live with the dignity means is not a right where I am silenced, I am cornered. No, that is not a right. That's not a life of dignity. If you want to live a dignified life, you should be a free person. And you should have the freedom to express your voice, not make the noise. I'm very clear about it. But this 19.1.2 says, this is the only restriction. Your right to freedom of speech and expression is conditioned by Article 19.2, which says, nothing in subclause A of clause 1, that is freedom of speech and expression, shall affect the operation of any existing law, we are not concerned, or prevent the state from making any law insofar as such law imposes. Now comes reasonable restrictions on the exercise of the right, that is freedom of speech and expression, in the interest of sovereignty, 100% it should be done. Integrity of India, yes, again 100% it should be done. Security of the state, yes, it should be restricted. Friendly relations with the foreign states, it should be restricted. That's very loose expressions. Public order, decency, morality, contempt of court, defamation, or incitement to an offense. All right, incitement and offense is also very specific. What is offense we know, and what is incitement to an offense also we know. All of us have been in the practice of criminal law, we know it. So as far as 5 aspects are concerned, the state can make reasonable restrictions in the exercise of freedom of speech and expression in terms of public order, decency, morality, contempt, defamation. Defamation also, we know what is defamation. Again, under the civil aspects and the criminal aspects of defamation. So let's leave defamation also. Let's take a public order. To some extent, we know what is public order. That means order in public. That means where in the public there is an order, there's a rule of law, to put it very simple. There's an order of life in public. Where that order is affected or disturbed, then the state can definitely intervene and maintain public order. This is the duty of the state to maintain law and order. This is not the order that's called public order. Then comes decency. Yes, of course. Your expression of speech and expression cannot be in an indecent manner. So that also be understood. Morality. Speech and expression cannot be for immoral purposes. The moment you say morality, then you go into the realm of your conscience, of sense of being right and wrong, good and bad, etc. So for the time being, let's to those aspects also. Now come back to the come to the only aspect of contempt of court, because that's the only thing that we are dealing today. Contempt of court. So the Constitution permits the state to make law, introducing reasonable restrictions on our fundamental right of freedom and expression in the interest of securing the institution from committing contempt of court. Reasonable restrictions on exercise of right, contempt is a clause in the interest of comes the contempt of court. So in the interest of contempt of court. So contempt of court as such is not defined in the Constitution of India. But we have certain references in the contempt as far as contempt of court is concerned. One, it is under Article 129 as far as Supreme Court is concerned. 129 says the Supreme Court shall be a court of record and shall have all the powers of such court, including the power to punish for contempt of itself. So contempt of court is referred to in Article 129 as far as Supreme Court is concerned. And as far as High Court is concerned, it is referred to and dealt with under Article 215 of the Constitution of India. Almost the same verdicts, where in high courts, every high court shall be a court of record and shall have all the powers of such a court, including the power to punish for contempt of itself. So a contempt of the court itself, the court, being a court of record, irrespective of any other law, it has an independent power. For High Court under 215, Article 215, and Supreme Court under Article 129. Well, here comes the Contempt of Courts Act 1971. It actually superseded an earlier act of 1952. Coming to this contempt of court, Actually, the first Contempt of Courts Act was passed in 1926. Well, the immediate supersession was of 1952. We have this Act 70 of 1971, Contempt of Courts 1971. It's very interesting if you see the purpose for which this enactment is made. We rarely see such a purpose being defined at the very opening of the statute. It says purpose of the statute. This purpose of the Contempt of Courts Act is to define, number one, and limit the powers of certain courts in punishing contempt of courts, and to regulate the procedure in relation thereto. So this Contempt of Courts Act is a very special statute where the whole purpose is to define what is contempt and to limit the power of the court. We have statutes where now defining the scope of the power. Whereas this statute, Contempt of Court Act itself is actually designed to limit the scope, limit the exercise of power, because this is a very voluminous, you can't say voluminous, is an awesome power. I must say awesome power conferred on the court, unbridled, unguided, I must say, unguided and unbridled, to punish for contempt of itself. So unless it is properly, because in the Constitution there is nothing called unbridled and unguided. It's against Article 40. So it should be properly guided and it should be properly regulated. Contempt of Courts Act, one way is intended to, one, to define, and two, to regulate or to prescribe the limits of the unbridled and unguided or unregulated power of certain courts. There are only two courts which can punish for itself, contempt of itself. One is High Court, the other is Supreme Court. So this act is intended to define the limits of, define contempt and to prescribe the limit of that power, not the scope of the power. This is very important. Limit the power of the court for punishing the contempt and to regulate the procedure thereon. And we have the definition of contempt of court under section 2. We are not concerned with the civil contempt because what is important and what is the topic for discussion is actually criminal contempt. It means one, which scandalizes or tends to scandalize, lowers or tends to lower the authority of any court, prejudices or interferes or tends to interfere with due course of judicial proceeding, interferes or tends to interfere with or obstructs or tends to obstruct the administration of justice in any other manner. So one is scandalizing the court. Two, what they call the interfering with the due course of judicial proceedings. Three, interfere or obstructing the due course of justice. These are the three broadly understood. These are the three areas where the contempt is sought to be defined under the Contempt of Courts Act. The next section, probably I would request you to bear in mind when we learn something about contempt of courts is, with all these regulation, procedure, definition, etc., any court can punish a person for contempt only if, let's come to section 13, only if no court shall impose a sentence on this act for contempt of court unless it is very important, unless it must be satisfied. The court must be satisfied. And I don't have to explain to you, my dear friends, and the legal fraternity, what is the meaning of satisfaction by a court. How does it get satisfied? It's not a satisfaction by the conscience. There's nothing called a judge getting a subjective conscience. Judge's conscience is the constitutional conscience, no other conscience. My sense of conscience may be formed by my religious feelings, religious ideologies, political ideologies, philosophical ideologies. Yes, my conscience can be formed that way also. But the moment you are appointed as a judge, your conscience means constitutional conscience, because you are appointed to to bear true faith and allegiance to the Constitution of India, that is your oath, and to uphold the Constitution and the laws made thereunder. This is your conscience. So what your conscience in the moral sense says is immaterial for a judge when he is exercising his duty. What the Constitution says, in a matter is what is called, constitutional conscience. So a judge's conscience is not subjectively constitutional, it is constitutionally objective. A judge's conscience is not subjectively constitutional, but constitutionally objective. Then alone, a judge can say, I have done everything with full satisfaction of my conscience. And that conscience, a judge should be claiming to have done full justice to the Constitution to the conscience is the constitutional conscience, and it's not your moral conscience. But so there must be a cause must be satisfied that the contempt is of such a nature. So what the level of satisfaction? It must be such a nature that it substantially interferes with or tends to substantially interfere with the due course of justice. Not simple. There must be either a substantial interference in the due course of justice, or there must be a tendency to substantially interfere with. We learned what is contempt under section 2, scandal, obstruction, interference. Where section 13 is very clear. Mere scandal, no. Mere interference, no. Mere obstruction, no. It should be, a court can punish a person for contempt of court only if the court is satisfied. That satisfaction is objective satisfaction. Objective satisfaction. What is objective satisfaction? That, somebody brings into the notice of the court that these are these are the materials on which I say there is a contempt. Then the condemner gets an opportunity to say, no, these materials are there, but I have a defense by truth. I have my own defenses, so let me defend. So when is he called to defend? Only after a prosecutor brings to the notice of the court that there is a contempt in the conduct of a person which substantially interferes with or tends to interfere with the due course of justice. Unfortunately, in the Prashant Bhushan's case, it was a case of prosecution without a prosecutor. There was no prosecutor. The prosecutor did not open the case. You're all seen the trial courts, no? Who opens the trial? Who opens the trial? Well, in the Prashant Bhushan's case, did anybody open? The Attorney General was issued notice. He was present, but he was not permitted to open. He was not. So only if he had opened and established that there is contempt, then this man would have been in a position to be called to respond or answer. You should be called upon to defend. Defend what? Defend what has been established against you. Who established? Nobody established. Because the judge becomes, or the court becomes the judge, witness, prosecutor, and whatnot. Everything. This is the procedural irregularity which has materially vitiated the whole case. This is my personal observation. Personal observation means it's not my conscience observation. This is the observation of a person who have been in the field of law for 42 years now, and for which God's grace 18 years and less than 19 years in the field of as a judge. Then comes why is this section 15? Let me draw your attention to section 15 also. Why is section 15 important? Section 15 is important because section 15 gives power to either to suo motu or on the motion of an advocate general. Why there should be a motion of advocate general or advocate general for a high court? And see, advocate general for a state is a constitutional authority. Don't forget, it's a constitutional authority. It's the right of prudence, and he is the leader of the bar. That is the definition of advocate general. The Attorney General for India also, the same position, is a constitutional authority. So a screening is given to that constitutional authority, where that authority will screen whether there is a case for prosecution for contempt. Then it should be filed before court. The permission is given. Then the trial starts. It's a trial. It's a trial, not in a repetition like somebody issuing notice, hearing, and finishing. No, it's an adversarial procedure. The moment you say it's a trial, it's an adversarial procedure. The contempt law contemplates, because being criminal contempt, where you are to be punished, is a trial in every sense of the term. So that is why Section 15 becomes very important, a screening by the Advocate General as to whether, or Attorney General, as to whether there is contempt or not. Now, Section 23. Section 23 gives the power to the Supreme Court and the High Court to make rules not inconsistent with the provisions of this Act, providing for any matter relating to the procedure. This is that the procedure regulating the contempt, other than what is stated in the Contempt of Courts Act. And Article 145 also gives power for the Supreme Court and the government, yes, to make rules, yes, with regard to the contempt procedure. Section 23 of the Contempt of Courts and Article 145. Those rules are made. And the Supreme Court also, maybe Jharkhand High Court would have made your own rules. I have not seen those rules. But I can tell you something about the Supreme Court rules. Supreme Court rules have been drafted in the year, promulgated in the year 1975. It came into effect in 75, yes. And those rules are called the rules to regulate proceedings for contempt of Supreme Court 1975. And Part 2 says, the Supreme Court can take action either suo motu or on a petition moved by the Attorney General or Solicitor General. But the Rule 10 is very important. This is where I want to draw your attention, and probably we can have a little interactive session now. Rule 10 says the court may direct the Attorney General or Solicitor General to appear and assist the court. In the case which I referred to, notice was issued. Notice was issued to the Attorney General. The moment the notice is issued to the Attorney General, the Attorney General gets a right of pre-audience. And he has to open, because he is also an officer of the court, as any other advocate. And he is the first among the equals, among advocates, when he appears in a court. Advocate General for the High Court and Attorney General for the Supreme Court. Well, that was also not done. So, my dear friends, this is actually the statutory framework, and this is the constitutional perspective on which we all understand what is contempt and what is the limit. Because this act is intended to limit the power, because a power that is otherwise, which is likely to be unbridled and unguided, because court in a suo motu contempt is the prosecutor, is the witness, and the judge. So therefore, there shall not be any casualty. And I, for me, took a different stand that, being a punishment, original punishment meted out by the Supreme Court in exercise of its contempt jurisdiction under Article 129. See, in a criminal jurisprudence, there is no question of a criminal proceeding whereby a person is punished, not getting an opportunity for a second look. There are two constitutional courts, one Supreme Court, the other High Court. If under Section 19 of the Contempt of Courts Act, if you are punished for contempt of court, you have a statutory right of appeal to the Supreme Court. It's a statutory right. One second. Let me take that section also. Yes. An appeal shall lie. As otherwise, you have no right of appeal to the Supreme Court. That's why it's called SLP, Special Leave Petition. Unless what the Constitution says, you have it in leave, or in the matter of death penalty, whether you have statutory interstate disputes. Well, so these are the matters where it is we have the right to approach the Supreme Court. As otherwise, you have to get a special leave. The court should give you leave for a civil appeal or a criminal appeal. Whereas there is an appeal, statutory contempt appeal is provided to a person who has been convicted for contempt of court in the High Court under Section 19. An appeal shall lie. It's a matter of right. As of right, it says, again says, strongly says, as of right, from any order or decision of a High Court in the exercise of his jurisdiction to punish for contempt, exercise of his jurisdiction to punish for contempt, that's under Article 215 in the High Court and 129 in the Supreme Court. Wherein the order or decision is not of a single judge, then intra-court appeal to the division bench. And the decision if it is the bench, then to the Supreme Court. It says right conferred by the Contempt of Court side. Whereas in the other constitutional forum, namely the Supreme Court, there is no right to appeal. So that is a failure of justice. There's a failure of justice. So the rules should be framed in such a way that the person convicted in exercise of its original jurisdiction for punishing for contempt should get an opportunity to have a second look in the same Supreme Court by way of an intra-court appeal. This is the stand I took. In fact, 2-3 things only I spoken out after my retirement. One in a situation, a different situation. And this is the second situation. Yes, after my retirement, I gave my public addresses. Of course, close to retirement, there have been many interviews. Thereafter, I did not speak out at all. And I spoke only in the year 2020 on 2 aspects. One in a different context, and this is the second context. I felt my constitutional conscience, which I have been trained and groomed, told me that it's a time that I should speak out, and I spoke on my own. I did not form part of the group. I spoke on my own that the majesty of the Supreme Court should be upheld, because it is the Supreme Court of India. It's the country's Supreme Court. It's not the order passed by A judge or a B judge or a C judge or ABC judges. No. These are all will go. Kurian will come and Kurian will go. But the Supreme Court of India will remain as a court of record forever. And that is the guiding light as the guardian of the Constitution. Not only to India, to the whole world, where this is the highest court of the country. And this is the only court in the whole world which has a lot of such vast powers. Powers for what? Powers not to be exercised like this. Powers to be exercised for upholding the majesty of law. Thank you, my dear friends. We'll have a little interactive session.
Thank you so much, sir, for this splendid evening. You have meticulously explained various provisions of contempt law. Indeed, today we are enriched so far as contempt law is concerned. Our heartfelt gratitude to your lordships for this wonderful deliberation. Now, I request the participants attending the webinar, if they have query, they can either put it on the chat box or they can just put the question to the Honorable Justice Kurian Joseph.
May I have the occasion
Yes.
to? May I have an occasion to put a query, my lord, for our clarification on the issue? If my lord may so please, with
Yes,
my lord's
please.
permission. My lord,
Yeah, please.
my lords, we several times come across a situation where I may not be taken otherwise or offending, but we several times come across a situation where the presiding officer of a court, be it the district court or the Honorable High Court, appears to act not in consonance with the proceedings, which is objected to by an advocate. Now, my lord, the contempt of court is with respect to the court as an institution, not with respect to the presiding officer of a court. So in my humble understanding, don't we need that there should be some guidelines or clarifications issued by a judicial pronouncement that when the presiding officer of a court can identify himself to the institution itself, and when there has to be a borderline drawn where the institution is not being attended with disgraceful words, rather there is some reservation with the appearing advocates with respect to the conduct of the presiding officer of the court. So there has to be some distinction between the institution and the presiding officer, so that it is not that one is taken for a contempt of court even if he objects to the procedure being adopted by the presiding officer.
Right, you want my observations on that. This question is asked by Mr. Bharat Kumar.
My lord, I am Rupesh Singh from Jharkhand High Court.
Rupesh Singh, okay, Rupesh Singh. I was just looking at the face. As Rupesh Singh, thank you for the question. See, one thing we must all keep in mind. See, unless the dignity of the court and the majesty of law are there, we ourselves will be left in the lurch. Don't forget that. We also get our stature and status because of the majesty of law and the dignity that is constitutionally conceived for a court, because it's a judicial verdict. And coming to the Supreme Court or High Court, you have a particular judicial review of administrative action or inaction, both. Coming to the trial courts, unfortunately, let me tell the other side also, because I've been part of this judicial academy for quite long, and even now I go as a guest faculty to Madhya Pradesh National Judicial Academy. See, what generally happens is, the lawyers terribly intimidate the presiding officer. The poor trial judges, they will say, no, you have been an officer, you have become a civil judge, maybe 2 years, 3 years, 5 years. You know how many years I've been practicing? If you don't do like this, we'll teach you a lesson. And then start writing complaints and motives. So you want an order the way you want it. This is unfortunately happening not in South, but in the North. I know because I have interacted with thousands of judicial officers in my career of 18 plus years. So all of them, they have been saying helpless. They said they become helpless. They don't have physical intimidation. And they do also. These lawyers write unnecessary letters for harassing, attributing motives, and they tend to corrupt also. I honestly feel no judge can be a corrupt judge without the intervention of the lawyer. All said and done, I must say this also. No doubt about it. Without the knowledge, if not intervention. Without the knowledge, if not intervention. Mark my words. No presiding officer or no judicial officer will be corrupt of a lawyer. Knowledge of a lawyer or intervention of a lawyer. Forget about it. That's a different issue. But what happens is, don't intimidate a judicial officer saying that, this is so, don't shoot bullets on it. But said and done, you are an officer of the court. You have a duty to the court. You have a duty to the client. You have a duty to your opponent. You have a duty to the society. You have 4 duties. No? So, as an officer of the court, how do we correct my father? Let me see. If my father does something wrong, how do I say? Better you correct your ways, better you mend your ways, otherwise I will shoot you. When I say like that, no. There is a way of correcting it. Even if saying that, no, you are wrong. We will not say the intimidating terms that no, you are wrong. We will try to put it to his notice that, he has gone wrong, or his approach is not right, or his decision is not right. He needs a relook. It needs to be reviewed. It needs to be looked into deeply, etc. So therefore, we all belong to a system where, without being intimidated by the court and without intimidating the court, we need to be partakers or participants in the system of administration of justice. This is very important.
We have another Ms. Suchitra Pandey.
Good evening, sir. We are extremely enriched by my lord's views on the contempt issue, and especially looking towards the present circumstances. And what arose in my mind while hearing to my lords is that when my lords was interpreting the act, my lord came to the point that basically the Contempt of Court Acts is a way of regulating the powers which has been already given immensely to both the courts. Now, there's the one part of the situation is what we are seeing presently, which all of us are having a view of, and there's another part of it is that a situation is there that we see every day. There are number of judgments of the Honorable Court which go uncomplied by the executive, I'll say. Now, what I understood is by saying that the Contempt of Courts Act is a way of regulating. It's basically the legislature which can come up with a law which will again regulate the powers of the courts. This is what I have understood, subject to correction by my lords. Now, to say that to regulate the powers which has been given to the courts on one side, and on the other side, the same executive which is part of the legislature is not complying with the orders of the court. And there's already a lot of, like my lord said, that there's a way of saying, coming up with a criticism, and there's another way of making noise. And there's already a lot of noise happening these days. So how do my lords will suggest that this be balanced? Because this is what came to my mind, to suggest the legislature that you please start regulating it further. How do we save the common, a rickshawala or a laborer who there's an order for payment of compensation which is not being complied for 10 years? Now how? Because there are two sides of it.
Sujitra, I understand the question. See, I did not deal with that part of the contempt which is called civil contempt, because the hot topic is criminal contempt. There are two types of contempt. One is civil contempt. Non-compliance with an order passed by the court is deliberate non-compliance is a civil contempt, for which you can punish that officer. Whoever is commanded by an order to do a particular thing within a particular time in a particular manner. If he does not do it in the way the court has ordered, if he does not do it within the time the court has ordered, and if it is not done by the person to whom the order is sent, these three situations, you can move the court for punishing that officer for committing civil contempt. That is wholly different from criminal contempt. Criminal contempt, civil contempt is actually defined, first definition is a civil contempt. That is section 2B. Civil contempt means willful disobedience or to any judgment, decree, direction, order, writ, or other process of a court, or willful breach of an undertaking given to the court. This is civil contempt, for which the punishment is apology 2006 months, and there is a limitation also 1 year. Whereas criminal contempt is wholly different. I told you, one is scandalizing, second is interference, third is obstruction. And the whole angle on which this law, I told you the purpose of law is actually limit the power, because it is what you call such a overwhelming power, all pervasive power. I must say all pervasive.
So my lord's suggestion is that the regulation should be towards the
civil contempt should be dealt with very seriously. If the court is taking a very lenient view in civil contempt, no executive officer, no authority will comply with the orders of the court. In the place where I was judge and chief justice in Himachal, you have as many writ petitions and as many contempt petitions also. Reason is, without contempt, normally officer will obey. I told after some time, I told the officers, I told the government, this is not the way. If you need a person to, this is not an execution petition of a decree. you can't take contempt as an execution petition. This is something very, it indicates a very bad governance. If you want to be a law-abiding executive, you must obey, subject to the finality available to an order. Unless the court shows its fiat, means strong for the timely, effective implementation of its own order, what you call it will affect the majesty of law and the dignity of the court.
Do we have any more queries?
So one question.
Yes.
Lord, I am Pandey Neeraj Rai, advocate practicing in Jharkhand High Court.
Yes, Mr. Pandey.
Lord, how do we reconcile few principles of contempt? One is that the contempt is a matter between court and contemner. The second principle is if an applicant comes and makes an application for initiation of contempt, he is faced with a law of limitation under the statute. Third is that under Article 215, there is a constitutional power. So there is no limitation. And fourth is a situation where we know that reasonable restrictions are incorporated in the Constitution because an exception to reasonable restriction would be public good. For public good, certain things can be permissible. So what if a contemptuous statement is made for a public good? What would be the answer of the court faced with such situations? Am I clear, my lord? What I am contending is there is a proceeding which is coming before the court, barred by a statute of limitation, barred by the law of limitation as provided in the 1971 statute. But a pressing case is made out for exercising jurisdiction under Article 215. And then somebody opposing it and saying that no, this is a matter between court and contemner, so it is sole and sole the discretion of the court to entertain or not to entertain. To go into the question of contempt or no contempt is the second phase, to entertain or not to entertain. And then a case is made out on merits that whatever contemptuous statement was made out, all ingredients of contempt fulfilled are made for public good or larger good. I mean, a good, something which is beyond the personal interest of the person committing contempt or the person who is the subject matter of contempt. How would we deal with all these conflicting situations?
Neeraj Pandey Rai, say this limitation of 1 year. Why is it given a limitation? Because the court does not want to conduct a post-mortem and then again unearth those things have already been buried. So we call it stale, stale claim is to say. So as far as the dignity aspect of the majesty of law, dignity aspect is concerned, if some society has forgotten for 1 year, let's not unearth it. If you were not keen for 1 year, then you can't get the other man punished. Does not mean that you have no other remedy. You have remedies. You must know as lawyers what to do next. Merely because you did not seek a contempt for 1 year, that does not mean that a writ in your favor does go futile. No, it doesn't go futile. There are other ways of implementing it, which I'll give you as a professional assistance. Now that I have retired, I ask for professional assistance. Yes. Yeah, there are other ways. It's not a futile. No writ is a futile writ. A writ is intended to be implemented. Get it implemented otherwise than through contempt route also. There's a route other than contempt route also. But as far as contempt is concerned, limitation is prescribed because if the society has forgotten about some scandal, let's not the court unearth it again. If the person has thought not to be disturbed, then let it not be. Whereas 215 is a different contempt. 215 is a contempt committed on the face of it. To me, I'm very clear about it. Suppose a person does not permit the court to dictate the judge, keeps on shouting. Number one. A person, a lawyer does not allow the other side to argue and abuses the court and abuses the judge and behaves in such an unruly manner that you cannot conduct the court. That is the obstruction. And that is actually contemplated under Section 14 of the Contempt of Courts Act of the High Court and the Supreme Court. As far as trial courts are concerned, they don't have such a power. They can only make a report, conduct an inquiry, make a report, and then it is for the High Court to take action on a report furnished by the judicial officer. Whereas High Court and Supreme Court, on the face of it, if something is done, they can punish. That's a very effective tool in the hands of the Supreme Court and High Court. If there is obstruction, if you see when it is alleged or appears to the Supreme Court or the High Court upon its own view that the person has been guilty of contempt committed in its presence or hearing, then the court may cause such person. So in the presence of the court and during the hearing, these are the two conditions for that.
So just that one sensitive issue which I also tried to touch, a contemptuous statement made for public good, larger public interest. Somebody could not resist the temptation of asserting something which amounts to contempt, nevertheless. How do we deal with that situation? Something like what Mr. Prashant Bhushan was claiming to have done might not have
These
found
two, Neeraj Pandey, these two things do not go together. Public good. Say, I can't take money from your pocket and give to a poor person who is starving. It's a public good because there was a person who is going to die. I just what you call overpower you, take the money, slash the chain, etc., and give them. That's also public good in a way. So public good and contempt will not go together. Whereas in the interest of the institution, where he is also a part, this is the plea taken by Prashant Bhushan. Just as the judges are also interested in the institution or concerned about the institution, I too, as an officer of the court, all of us as lawyers, as officers of the court, you know our definition. We are defined by the Bar Council as gentlemen. Therefore, what is ordinarily permissible for a layman will still be not permissible for a lawman because we know what is law. This is our definition. So, contempt for public good is not right. Contemptuous conduct for public also is so good. But telling the king that you are naked is not contempt. This is my stand. If you are naked, you are naked. And there should be somebody should tell that you are naked. Others may shy away. Others may not want to do it. Why should I tell my father that he is naked? Why should I quote the wrath of my father? If he is naked, let him suffer. No. Those who love their father will always say, Father, you are naked. So this comes out of the love, not out of contempt. That's the difference.
I'm so very grateful. Thank you very much. It was a privilege to hear your lordship on this.
Thank you. Thank you, Neeraj.
We are so grateful to your lordships. Now, I would request Mr. Bhanu Kumar to kindly convey the vote of thanks to our Honorable Justice Kurian Joseph.
I'm sorry, I too addressed you as Bharat Kumar because your name is written as Bharat Kumar. So Bhanu Kumar, yes. I'm happy that seniors like you are also present in this seminar, because you are the people who are to guide the next generation in this noble profession.
My lord, his son is a practicing lawyer. His name is Bharat Kumar. Therefore, it is reflected there. He is actually Bhanu Kumar. His son's name is Bharat Kumar. He is a lawyer in Jharkhand High Court.
Okay, that's very good.
Yeah, my lord, it is our privilege. Today is a red letter day for all the lawyers and participants of Jharkhand High Court that my lord has spared precious time, and as it has been said that brevity is the soul of wit. In very brief, my lords have delivered some original thoughts. I don't want to say much about the career of my lords, as Rahul has already explained, but what I find that there is almost balance. My lords, the bench for about 18 years, and on bar side also for 20-21 years. So there is sort of balance. Today's topic is also contempt of courts versus free expression and need for delicate balance. So my lords have played on both sides of the field, and he is having immense experience. Now, one thing we admit, that my lord is very candid and frank in his expression and views. And this view is not for lending support to someone, but it comes from within my lord's conscience, and not other conscience, religious conscience, but judicial conscience, the long and vast experience which my lord has gathered. So that judicial conscience, and it is duty of my lords towards the society, towards the country, to contribute something to the framing of our constitution, developing of laws. Now, today we found one more thing which is very amazing and is startling about my lords, is that this leadership quality is embedded in my lord since his student days. I have gathered from Google Baba that my lords were general secretary of his students' union, and so many offices, innumerable offices. So that leadership quality, my lords, and how to express and place the thoughts in a free and frank manner. So this is an innate quality which we found today also. The topic itself is very hot and sensitive. My lords started with freedom of speech and the preamble. Freedom of speech, Article 19, 14, and 21, they form the golden triangle of our constitution. And freedom of speech, which is, my lord, buttressed by the preamble, that is dignity of an individual. So it attains a very high pedestal. My lords, in Article 14, the onus is very heavy. If someone wants to prove that discrimination, unreasonableness, arbitrariness, the onus is very heavy. But under Article 19, if we ex facie prove that my expression is being curbed, the onus shifts on the other side. So this very finely delineates the difference. Then, my lords, one original thing which we learn today, that what is democracy? Democracy is not a dead democracy. It should be living and it should be vibrant. And right to space and voice. See, this doctrine of space, my lord, this is an original concept of my lords. We are hearing for the first time. This is very vital. If we don't have space, how we can enjoy the democratic fruits? Then my lords told about the difference between the constitutional powers of the higher courts as enshrined under Article 129 of Supreme Court and 215 of the High Court, and then the Contempt of Courts Act. Now, what is very vital in Contempt of Court Act, which is a parliamentary statute, that it doesn't expand the power, it limits the power. That is the catchword, my lords. So it means that contempt power should not be awesome, unbridled, unguided, or unregulated. I am using the phrases used by my lords. And thereafter, my lords, sections of the Contempt of Courts Act. And then the most important aspect is that if the High Court punishes, he has got a right to appeal, either before the division bench or by way of SLP. But in Supreme Court, there is no provision of appeal. So there must be a sort of provision, SC rules, Supreme Court rules for intra-court appeal. At least, my lord, second look. I'm using my lord's phrase. Second look, because someone is being punished, his liberty is being curtailed, his white shirt is being tarnished with black tar, and it can lead to many consequences, suspension of license, or so many things. So my lord have also voiced before many press conferences that the provision of intra-court appeal is mandatory, it is a sine qua non, and the rule should be accordingly suitably amended. So, my lords, very nicely, in a very brief manner, we know that many important judgments my lord have delivered, coal allocation, CBI, cased parrot concept was shattered, and other cases, my lords. C judgment, for which my lord is, of course, giving a second thought that it should not have been the way in which I did. After every day, man becomes wiser. And my lords, the historic day, I just don't want to refer the date, January 2018, because Bertrand Russell has said, my lord, when sane advices, sensible advices, they go unheard, then at times for drawing the attention, such historic steps has to be taken. And my lord was there, and my lord is not happy. My lord did not name that after retirement, judges should avoid any engagement. So, my lords, we are very happy and fortunate that today my lord spared his precious time. And since my lord is not interested in any sort of employment, so we can only offer our best wishes for a happy and prosperous life. And my lord is looking as young as ever. The spices of Kerala. Good health, my lords. The spices.
Mr. Bhanukumar, I didn't go to Kerala. I stay back in Delhi. I proposed to stay back in Delhi for some more time because I thought I could do a little more service here. I do my arbitrations, my mediation. I'm a passionate mediator. I do my mediation. I do my consultation, conciliation. Whatever I can do, I still. But I will not take up any assignment.
We get couriers. We get couriers of spices from Kerala. Then why my lord is having his native village? He can of course get.
Yeah. So for the last 6 months, I could not bring any load because I used to go to Kerala every one. But 6 months, there's no flight. What to do?
My lords. So, my lords, we are very happy, and we will again.
By chance, in Jharkhand High Court, nobody has come from Kerala, no?
No.
My lords,
Honorable Justice,
one personal experience.
The first
I have
chief
been a student of.
Honorable Justice Subramaniam had come as Chief Justice.
Who?
Balasubramaniam, Mr. Balasubramaniam.
Oh, Justice Balasubramaniam was there. Yeah.
Yes.
He was elevated.
Odisha, Jharkhand, Supreme Court. Yeah.
So, my lords, we are very happy, and we will not spare, my lords. We will again, after a gap of 1 month, 15 days, 2 months, we will request and humbly pray that my lords again chooses a very nice topic, relevant and contemporary topic, and enlighten us.
Who is the Chief Justice now?
So we have, my lord, he is Dr. Ravi Ranjan, Honorable Justice Ravi Ranjan. He is from Patna High Court, my lords.
Oh, yeah, I know. Yes. Please do extend my warm regards.
Lordships, we will.
Mr. Rahul.
My lord,
So now I thank all the participants. Pandey Neeraj Rai is on the screen, Mr. Avnesh Ji, Mr. Manoj Tandon, ex-Advocate General, Mr. Rupesh Kumar. I could see them on the screen. And all the participants, I am thanking them. And my special thanks to Rahul Sabu, my lord, who is instrumental in organizing such webinars, illuminating webinars in this pandemic period. So he needs a special thank from all of us. So once again, my lord, we are wishing a very bright future, happy life and prosperous life for my lords. Thank you, my lords.
Thank you so much.
Thank you. God bless you all. Stay blessed. All the best.
Thank you.
Thank you so much, sir.
Thank you.